A company is legally recognized as a separate entity from its owners. This means it has its own rights and responsibilities. It can be sued or be sued, own property, and continue to exist indefinitely. Despite this perpetual nature, there are circumstances when a company's journey must be come to an end. This formal ending process is known as a winding up or liquidation. So, in Malaysia, winding up is governed mainly by the Companies Act 2016 and the Companies Winding Up Rules 1972. This process is essential as it assures that a company debts are settled with creditors. Any remaining assets are distributed fairly and the company is officially and legally dissolved. Understanding winding up is crucial to appreciating how companies responsibly conclude their affairs within the legal frameworks. When a company decides or is forced to cease operation and settle its affairs, this process is called winding up. It can happen in two main ways. 1. Voluntary winding up. This type of winding up is initiated by the company itself without any court intervention. It comes in two forms. Members' voluntary winding up, which occurs when the company is solvent, which is able to pay its debts, and second, require a special resolution passed by the shareholders. The second one is creditors' voluntary winding up, happen when the company is insolvent, which is unable to pay its debts, and creditors are involved in overseeing and directing the winding up process. The second is compulsory winding up by court. This is the court order process and can be initiated by the company itself, a creditor with a minimum debt of 50,000, a contributor, a liquidator. It must be based on statutory grounds under Section 465 of the Company Act 2016, such as inability to pay debts, it is just and equitable to wind up the company has not commenced business, and failure to file statutory reports.
Right. Okay. Thank you, Ivina, for the introduction. And hello, madam. My name is Ahmad Naim bin Atamandan, and I will be presenting you my part, which is part 3, 4, and 5. Now we will move on to part 3 first, which is the role of liquidator. Once a liquidator is appointed to a company, they take full control over its affair. From that point on, the company director lost the decision-making power, which suspended through the liquidation process. So, what exactly is or does a liquidator do? The liquidator has 3 key responsibilities. The first is they gather and sell off the company asset. This means they convert all the physical and financial asset into cash. The second is that they use that money to settle the company debt. So this includes paying creditors according to the legal order of the priority. And then the third one, which is if there is any money left after paying the debt, the liquidator will distribute the remaining funds to the shareholder. In short, the liquidator play a very important and authoritative role. They ensure that the company is closed down legally, fairly, and efficiently. I will now move on to slide 4, which is winding up process, step-by-step overview. Now, let's go to a simple overview of the winding up process in the 4 steps. The first step, which is asset realization, the liquidator start by identifying and selling the company asset to convert them into cash. Number 2, the debt settlement, which is basically the money collected from selling the asset is used to pay the creditors. Secure the creditors are paid first, followed by other creditors who are according to the law. Now, the third one is distribution. If there are any surplus remaining after all the debts are paid off, it is distributed fairly amongst the shareholders. And lastly, final dissolution. When everything is settled, the company is officially dissolved and removed from the register. This marks the complete closure of the company. That is it for part 4. I will now move on to the fifth slide, which is legal grounds and case reference. Now let's look at the legal ground for winding up a company along with some key case reference. Section 465 1E, inability to pay debts. Under this provision, a company can be wound up by the court if it is unable to meet its financial obligation. In simple terms, if a company can pay its debt as they fall due, if they fail the due date, is a clear legal ground for compulsory winding up. Now, number 2, just as an equitable ground. This is a more flexible ground where the court may decide to wind up a company if it's fair and reasonable based on the situation. But let me explain some of the well-known cases that this has happened before. First is the RE Wenidje, WENIDJE Tobacco Co. Here, the director were in a deadlock and could no longer work together since the management was paralyzed. So the court intervened under the just and equitable grounds. Locke versus John Blackwood. This case involved mismatched management. The court found that the company lacked transparency and trust. So it was just and equitable to wind it up. The next one is German Date Coffee Corporation. In this case, the business of the company had failed. Reason for that was there was no chance of reviving or redirecting the business. So the court just allowed the company to be wound up. These cases show how the court can step in when the company is unable to function properly, whatever due to financial issue, internal conflict, or failed purpose. That is it for my part. I would like to pass this on to Afifa for her part. Thank you so much, madam, and have a nice day.
So thank you, Naim, for presenting. So my name is Nur Afifa binti Afendi, and I'm presenting about section 6, 7, and 8. For section 6, let's begin with some important legal consideration, especially related to bankruptcy. First, the minimum debt requirement in Malaysia is 50,000 ringgit. This means a creditor can only file a bankruptcy petition if you owe it at least this amount. If the debt is disputed, you can apply for fortuna injunction. This helps stop the petition from proceeding until the dispute is resolved. Be aware that even if a petition is a later dismissed, the repetition risk can still be effective to you significantly. So it's important to handle things such matter carefully. And next, let's talk about a partnership, a popular business form in Malaysia. A partnership is formed by agreement between two or more people. While this agreement can be verbal, having a written partnership agreement is strongly advised. It's like a provision, management. Every partner has equal right to manage the business. Legal relationship. Partner are agent of the partnership, so decision by one partner can bind all. Obligation, partner must be honest, share profit and losses, and avoid competing with the businesses. Liability, partner can join several liability, meaning any partner can have personally responsibility for the amount of their debts. Finally, let's compare companies with the other business form like sole proprietorship and partnership. They're very different. They are separate legal entity, not separate. Like for the sole property, they separate legal entity, but partnership not separate liability. They have limited liability for shareholders, unlimited liability for owners, compliance, and capital raising. So in summary, companies offer more protection and capital opportunities but come with strictly regulation. Partnership are easier to manage but come with facilities. So I will pass this to...
Thank you, Nur Afifa, for the clear and insightful explanation. Hello everyone, and a warm greeting to our respected lecturer, Madam Bella. My name is Nur Afifa Batrisha, and I will now continue the presentation on this topic. Let's start with the next point, which is special features of company incorporation. Incorporating a company in Malaysia brings unique benefits that set it apart from other business forms. First, a legal entity means the company is recognized by law as an independent person. This allows it to own assets, enter into contracts, and even sued or be sued in its own name. Next, we have limited liability. This means that shareholders' financial risk is limited only to the amount they invest. Their personal assets are protected from any company debts. Another important feature is perpetual succession. The company continues to exist even if shareholders or directors change or pass away, which ensures business continuity. Then there's the corporate constitution, which is guided by the Companies Act 2016. This document outlines internal rules, including shareholder rights, the duties of director, and how decisions are made. Importantly, any amendments to this constitution require a special resolutions, which ensures that significant changes have broad shareholders' agreement. The next point is key rules in governing capital, management, liquidation, and listings. To fully grasp how companies operate, it is important to understand the legal rules surrounding capital, management, winding up, and public listing. Let's begin with the capital structure. We have three legal terms here. Number one, which is authorized capital, refers to maximum number of shares the company is allowed to issue. Number two, which is issue capital, is the number of shares the company has actually offered to shareholders. And number three, which is paid capital, is the portion of shares that shareholders have fully paid for. When it comes to management, it is governed by board of directors. They are responsible for strategic decisions and overall governance. Additionally, shareholders come together annually at the annual general meeting or AGM to review company performance and make key decisions. Moving on to liquidation or winding up, when a company stops operating, a liquidator is appointed to take control. This person prepares a detailed statement of affairs, verify creditor claims, sell the company assets, pay off debts, and distribute any remaining surplus to shareholders. Once this process is completed, the company is officially dissolved. As for public listing, company aiming to be listed on Bursa Malaysia must meet strict regulatory standards. These include regular financial disclosure and corporate governance reports, which help maintain transparency and accountability. The legal framework supporting all this process include the Company Act 2016, which governs companies' formation and operation, and the Insolvency Act 1976, which regulates liquidation and insolvency. Additionally, Suruhanjaya Syarikat Malaysia, or SSM, provides guidelines on operational and compliance standards. To conclude, winding up a company is a vital legal process. It ensures an orderly and responsible closure, where creditors are paid and assets are fairly distributed. Understanding the differences between voluntary and compulsory winding up and the crucial role of the liquidator is essential for good corporate governance. Moreover, having a clear grasp of the rules surrounding partnerships, different types of company, and corporate structure help us better understand Malaysia's business environment. At the core of all this, the Company Act 2016 serves as a strong legal foundation. It promotes transparency, fairness, and accountability throughout the dissolution process, protecting the interests of all stakeholders involved. And that concludes our presentation. On behalf of everyone, I hope this has helped you get a clearer understanding and deeper insight into this topic of winding up. Thank you for watching!